A common question before filing for divorce in Florida is simple. How long is this actually going to take? This video covers the general timeline for an uncontested Florida divorce, from filing through the final hearing. One rule applies no matter which uncontested path a case follows. Florida Statute Section 61.19 provides that no final judgment of dissolution of marriage may be entered until at least 20 days have elapsed from the date the original petition was filed, unless the court finds that this delay would cause an injustice. That's a floor, not a target, and it applies to simplified and standard uncontested cases alike. Florida's simplified dissolution process, using Form 12-901A, is generally the fastest uncontested track. It's available when both spouses agree the marriage is over, have no minor or dependent children together, have already divided their property and debts, and are both willing to attend one final hearing together. According to the Miami-Dade County Clerk of Courts, the final hearing in a simplified dissolution case is typically scheduled approximately 30 days after the filing date. Timing varies by circuit and by how each county's family court calendar runs, so treat about a month as a general expectation, not a promise for every case. Not every uncontested case qualifies for, or chooses, the simplified track, for example when there are minor children involved or one spouse wants to file individually. That's the standard dissolution process instead, and it generally takes longer because it involves more required steps. The general steps are filing the petition, along with a parenting plan and child support guidelines worksheet if there are minor children, formally serving the other spouse, unless both spouses sign a written waiver of service, a response window for the served spouse, mandatory disclosure of financial information, generally supported by a financial affidavit, the parent education and family stabilization course required for both parents when minor children are involved. And finally, a final hearing once the required paperwork is in order. For a fully cooperative case with no property or custody disputes, this standard uncontested path generally takes several weeks to a few months, depending on how quickly both spouses complete the required paperwork and courses, and how the circuit schedules uncontested hearings. It's still subject to the same 20-day minimum under Florida Statute 61.19. A few things commonly add time even in an uncontested case: missing or incomplete mandatory financial disclosure, a parent not yet completing the required parenting course, a busier family court docket in a particular circuit, and paperwork the clerk rejects for missing signatures or incomplete forms. Genuine agreement between both spouses, a signed marital settlement agreement, and complete, consistent paperwork from the start all tend to keep a case moving. Virdix checks eligibility for Florida's simplified dissolution track and prepares the matching Florida family law rules of procedure forms from your answers, whether that's the simplified petition or the standard petition for your situation. Completing consistent paperwork on the first try helps avoid the clerk rejections and missing document delays that can add weeks to a case. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help keep your paperwork from being the reason a case takes longer than it has to.